All right, good morning. I see some people are still connecting to audio. Looks like everybody's here now, and we are live streaming on YouTube, and it is 9:30. So I will go ahead and do agenda item 1, which is call the meeting to order. It is 9:30 a.m. on December 16th, 2021, and I'll call this meeting of the Citizens Clean Elections Commission to order. I would like to ask audience members to please keep their microphones on mute. And with that, we will take attendance. If commissioners could identify themselves for the record.
Commissioner Mark Kimball.
Thank you.
Good morning, Commissioner Damian Meyer.
And I'm Commissioner Amy Chan. I don't see any other commissioners in attendance, I don't believe. So we've got a quorum, 3 of us, and with that, we can move on to agenda item 2, rolling right along. Item 2, discussion and possible action on commission minutes for October 29th, 2021. Is there any discussion? If not, do I have a motion to approve the minutes?
Madam Chair,
Commissioner Kimball?
I move we approve the minutes for the commission meeting of October 29th, 2021.
Thank you. Do I have a second? Commissioner?
I wasn't there, so I don't know if technically second this motion, so I would defer to the chairperson.
Maybe I'll go ahead and second it if I'm the only one left. And with that, we can go ahead and vote on that. Commissioner Meyer, do you want to vote on it or?
So I'll vote aye.
Okay. Commissioner Kimball?
Aye.
And I'll vote aye as well. And with that, we can move on to agenda item 3, discussion and possible action on executive director's report, enforcement and regulatory updates, and legislative update. Tom is going to go over this for us today, as always. Thank you, Tom.
I swore I wouldn't do that. Thank you, Madam Chair, Commissioners, and thanks everyone for being here. I know we have a lot of work to do, but I think, just the last 6 weeks have been very productive for the commission staff. First, though, I want to say congratulations to Avery Zola, who earned his Master's in Public Administration from ASU this month. We're all excited about that, and that's pretty cool. I think he's out today, but nevertheless, we are very excited about that. The legislative session starts in a little less than a month now, so before we next meet, the legislature will have started. I want to hit a couple of the things that are highlighted in the voter education section. We had just yesterday we had a online webinar that we hosted with the Arizona Capital Times about the midterms for 2022. It was really, really well done. Gina and Ken Mata, who's the security chief for the state elections, and Scott Jarrett, who's the election director for Maricopa County, and Paul Sensman, who many of you may know is a longtime lobbyist and communications expert, one of the most well-respected members of the government affairs community here, and they really provided a lot of wonderful information, and it's always great to see. And I really can't commend Gina enough for her work on that. Gina was also a judge in the We the People regional competition with the Center for Civic Education this weekend, which was very exciting. We're very proud of that. And obviously you can see the variety of outreach activities that Avery and Gina and Chairwoman Chan have been involved in the last month. We will have more on voter education for 2022 in January. Sorry, yes.
No, don't be sorry. I'm interrupting you, but I was really interested to see that Gina met with someone from the Carter Center, because I believe, and it was to discuss election observers at the polls. I was curious to hear a little more about that meeting. I'm interested because I think the Carter Center has been around for, I don't know, a long time. And my understanding is that they have never thought it was necessary to take a role in domestic election affairs before. They've always done international work. And with the situation in our country being what it is, they've started doing some work here within the US. And I just wondered, would it be all right to ask Gina to tell us a little bit about that meeting?
Surely.
Okay, Gina?
Madam Chair, Commissioners, good morning. So the meeting, the Carter Center reached out to Clean Elections, and they were looking to speak to stakeholders in the state just about the idea of having nonpartisan election observers stationed at the polls, and very initial discussions. They were, the Carter Center expressed that, they don't have anything written down. They were really just kind of putting the topic out there and just starting very initial discussions on it. So they didn't really have any type of, framework or game plan, if you will, about what it would look like. They just wanted to start those conversations with key stakeholders in key states that they were looking at, Arizona being one of them. So I met with a representative, and it was a fantastic discussion. And really what they were looking at is, would it be beneficial to have somebody who is, nonpartisan in nature, be there in the polls? Would that benefit the voters? And so we had a good discussion about what that would look like. There, in my opinion, I initially, I see a lot of challenges with doing that. And so we had a good discussion about a lot of things that they would have to work through if they wanted to pursue that. And mostly being kind of, what is the end game? What is the purpose of that nonpartisan person being there? When you talk about political observers, they have a specific function where they're taking notes and they're reporting back to their party. And, eventually, if they go to court, if they end up contesting the election, those observers could be called in as witnesses. So there's specific roles that the political party observers serve for kind of that end game, if you will. What does it end up occurring? So what would be the function then of that nonpartisan observer? So who are they really representing there? And then also we talked about voter perception too, such as the term nonpartisan. As we know here at Clean Elections, we have to often, I think sometimes you have to earn that title, and not saying that the Carter Center certainly hasn't earned that, but when you're a voter too, talking about perceptions, when you go into a polling place, how do you identify that person? Do you know who that person is? Do you know that they're, with a nonpartisan entity, or is it, something more comfortable for a voter to see a person of each major political party there to provide that balance? So lots of just initial discussions, things to think about, not necessarily a good thing or a bad thing, but it was, again, just, what are some of the things that popped into our head when we first started talking about this? What would it look like? And really, what's that ultimate goal of having that observer there? So that was really what the main points of the discussion ended up being.
Thank you so much for that overview. I was really curious to hear a little bit about that. Thank you. All right. Does anyone have any questions for Gina? And if not, I'll throw it back to Tom. Thanks, Tom.
Thank you, Madam Chair. Members, just really quickly, we will meet again on January 27th. I wanted to mention Paul and Mike have been coordinating our work with the Auditor General's office. As you all know, under 16949, we are the fund and its expenditures and revenues are audited every 4 years by the Auditor General. We've had productive meetings with them. They've been wonderful and professional to work with. I really can't say enough good things about them. And of course, Mike and Paula have been easy for them to work with, which I think is important as well. So we look forward to the results of that. You may look out in your own emails for a message from them in the next few weeks relating to whatever the audit resolution is. I wanted to mention a couple of legal issues I think are worth noting. We have 2 cases pending respecting the commission. One is the Legacy Foundation Action Fund matter at the Court of Appeals, and the other is the Power Fives versus Clean Elections, which is also part of the related, in a way, to the enforcement item. An important election case that was decided in last week, the Ninth Circuit Court of Appeals overruled the district court and found that Arizona's standard, where if you have failed to sign your ballot affidavit envelope and fail to rectify that before 7 p.m. on election day, that is constitutional. That means that the law that's on the books is still on the books, and it makes it incredibly important. Well, it was always incredibly important, but it makes it reemphasizes how important it is to sign your ballot return envelope affidavit. I want to mention, I'm not a real expert in election contests, but there is a case out there called Torguson v. Town of Gilbert, and it has to do the operative facts. The reason that it's on the list here is because the operative facts involve a town taking down political signs, and part of the town's defense, which is relevant to the campaign finance system, is that in effect the town was entitled to take these signs down because they were put up by an individual, not by a political committee. Though, since we've all been here for a while, we might recall there's a case called Galassini v. Fountain Hills that came out of the federal courts in 2013 that struck down the then existing political committee definition, in part because of the burdens, the way it was drafted and how it was sought to be imposed by the town of Fountain Hills. Again, I don't pretend to know the first thing about election contests, but I do think we need to be aware of the arguments that the town is putting forward and how they affect the overall operation of the campaign finance system, because these concepts are not entirely separate. I wanted to really quickly hit, and I apologize, it's going longer than I expected. As you can see, Gina, Alec, Avery, and the chairwoman have been either certified or recertified as election officers through the Secretary of State. Another thing we're just keeping an eye on is the Secretary and the Attorney General's office. I can't really characterize it beyond the fact that there's some kind of argument relating to the approval of the election procedures manual. Again, why is that something that we're asking you to keep an eye on? It's because the Secretary's office historically has, had the election procedures manual has always been a place where the Clean Elections role and the Secretary's role come into play with one another. And of course, obviously, from a voter education perspective, where the manual is, what the law is, those kinds of things are important. So, we'll be tracking that, but we don't have any insight or inside information other than the information that has been made publicly available by the Secretary, which we have if you want it. Finally, I want to say this, and this is important for administrative law purposes. Our regulatory agenda for this year, we're going to finish this year. This meeting, I hope. We do not have additional rulemakings we intend in 2022. If something comes up and we have to, obviously we'll update that and make people aware of that. But I just want to make sure that we make our annual statement of what our regulatory agenda is, and that is it. So unless anyone has any further questions, Madam Chair, members, thank you very much for your time this morning.
Thank you, Tom. I think I'm the reason that it went longer than you expected. Does anyone, do any commissioners have any comments or questions for Tom? I'm so thrilled and impressed with Avery, by the way. Oh, I see Commissioner Meyer's hand is up. Go ahead, please.
I just want to make a quick comment. Thank you, Chairman. Voter education is more important right now than it has been in my entire time on the commission, I believe. I'm just really thankful and proud to see what Tom and Gina and Avery and the whole staff are out there doing on the voter education to combat all the misinformation out there. So thank you. Keep up the great work. I know we're going to see your plan in January. I'm looking forward to that. But I just wanted to thank you and encourage you to keep it up, because we and the state, the citizens of Arizona, need you guys now more than ever on this front. So thank you.
Well said. Agree 100%. Thank you, Commissioner Meyer. All right, if there's nothing further on this item, we'll move to item 4, which is the budget. Discussion and possible action on the 2022 budget and related statutory calculations. So every year we approve a calendar year budget along with certain calculations required by law. And there's a memo in the materials at item 4, which outlines those calculations and our plan for 2022. And I believe this is Mike's item to present and answer questions. Thank you, Mike.
Yeah, good morning, Madam Chair, Commissioners. Before you is the proposed commission budget for calendar year 2022. Just a few highlights I want to touch on. First, the expenditure cap has increased. It went up about $1 million from last year. So that's a good sign, which allows us to increase our both our administration and our voter education caps going into 2022. Though one downside, if you look at the projected revenue going into 2022 and moving forward for the next 4 years, we are projecting a decrease in our revenue. We did see that this year, and we are likely to continue to see that. Now, that being said, the Clean Elections Fund is flush with cash, so we're not anticipating any concerns or issues when it comes to funding our candidates moving forward for the 2022 election cycle. Another area I want to highlight quickly for you is in both on the admin expenditure projections as well as the voter education expenditure projections. The rent charges for the agency, those have increased. That is due to the fact that we're moving to a new building sometime in July, August timeframe, and the rent will increase in that. And so I've also budgeted funds in there to offset any costs that may be incurred for the movement, taking down our desks, moving them over, assembling them, all that type of thing. So that has increased from previous years. Another aspect that I want to make sure you're aware of that has increased dramatically is under the voter ed side. If you look at the other professional outside services, that is about a little over $3 million. That is a substantial increase from previous years. That is due to a couple of things. One, a lot of what we're doing in our IT side is moving from our actual servers in hard servers to going to the cloud. So that's going to cost some funds, as well as being prepared for anything that may come along through 2022. I know in previous election cycles, we've been asked to be involved in different federal races in terms of debates. We want to make sure we're prepared for that. And along that line, maybe the congressional races as well. But we just want to be prepared so that we can jump in at any time and make sure that Clean Elections is involved in all these aspects, just like we've been doing in the last couple of election cycles. And we want to increase that for on the voter ed side. So if you see that, that's why that number has increased. One last area I want to point out is, again, our expenditure cap and our balance. If we were to spend all the way to the cap, we would not have any funds available. That's why we always continue to say, let you know that we recommend not having any. We don't have any funds available to give to the general fund moving forward in 2022. We want to make sure we have the funds available, which we do and continue to do, to fund all of our candidates. And with it being a bigger election cycle because of the governor's race, Secretary of State, all the statewides are going to be running. We're going to make sure we still have the funds available to fully fund every candidate that wants to run as a clean elections candidate. And with that, I'm happy to answer any questions.
Thank you so much, Mike. This is something that's extraordinarily complex to my mind, but may not be to others. Commissioner Kimball, did you have a comment or question?
I did. Mike, you talk about revenue projections, and I'm looking at page 10 of the attachment, anticipated fund balance projections over the next 4 years. And projected revenues are flat to dipping a little. Is this because of a decrease or a projected decrease in court assessments, or uncertainty about court assessments, or what is the reason for this?
Madam Chair, Commissioner Kimball, that's exactly it. It is the court assessments. The court assessments have decreased over the last several years, and this is our way of just being cautious, not knowing where the court assessments will be moving forward, and that's why the numbers are what they are.
And why have they decreased over the past couple of years? There was a legislative action, I guess it was a year ago, that allowed judges to waive certain fees, but I don't know that that's really taken. Do we know if that's really had much of an effect, or is it some other factor?
Madam Chair, Commissioner Kimball, at this point we don't know. It has been in place long enough to know whether that's really affecting it. The biggest issues when it comes to our court assessments is the lack of drivers on the roads. That's what, as the pandemic hit last year, and we've seen the lack of drivers on the roads, that's where the numbers come in. Most of our funding for the commission comes through that 10% surcharge on traffic tickets. With the numbers of drivers dropping, those aren't occurring as often. So on one hand, that's good. People aren't getting in trouble with the law, but for us, it hurts our funding. The other areas is, again, which the traffic, the red light running, those cameras, they are sporadic throughout the state, as the legislature has gotten rid of most of them. So those funds, what used to be a considerable amount, have dwindled to basically nothing at this point. So it really boils down to, we need more cars on the roads.
Interesting observation. Thank you.
Thank you. Any other questions or comments? Okay. Yeah, that is interesting about the cars on the roads. I have to say, I'm back driving now that my kids are back in school, and I haven't really noticed fewer cars. I don't disagree with what you're saying, but I've definitely noticed more aggressive drivers and faster drivers. It's like it's all been pent up over the past year. Crazy. Okay, so if there's nothing further, question or discussion wise, could we get a motion to approve the memorandum in item 4? Commissioner Kimball or Meyer?
Madam Chair,
Yes.
I move that we approve the memorandum regarding budget projections in item 4 of today's meeting.
Thank you. Is there a second?
Commissioner Meyer, I'll second that motion.
Thank you. All right. Item 4 has been moved and seconded. We'll go ahead and call the roll. Commissioner Meyer, how do you vote?
Aye.
Commissioner Kimball, how do you vote?
Aye.
And I vote aye as well. By our vote of 3 ayes and 0 nays, we have approved the item. And we will, congratulations, everybody. Good work. Good work. Thank you, Mike.
Thank you.
Moving on to item 5, discussion and possible action on amendment to our 220-101 rule amendment related to personal and family contributions to candidates participating in the Clean Election Funding Program. We approved this rule for public comment in July, and you may recall the staff worked with Governor's Regulatory Review Council to develop a clear rule proposal to resolve an issue related to the cross-references in the Act's definitions. Tom, would you like to provide a brief summary of this draft and your recommendation?
Sure. Madam Chair, Commissioners, yes, as Chairman Chan said, we have had this rule. This is the second version we've worked through after we got some good feedback from the Governor's Regulatory Review Council about trying to smooth and make sure the language was clear. The upshot of this is that there's a definition of family member for purposes of the traditional candidate contributions, and essentially family members' donations are considered essentially personal monies for all practical purposes. They are deemed to not have the corrupting influence that monies from non-family members would have. In 2016, the legislature expanded the definition of who was a family member for purposes of that definition. Because of the cross-references in the Clean Elections Act, the reverse happens. In effect, and we had a rule that was set up under the old system. So, in other words, when the legislature broadened the definition for the purposes of who can give to traditional candidates, it narrowed and put in under the category of family members the definition for purposes of clean elections. What does that mean? To be more precise, the Clean Elections Act limits participating candidates on the amount of personal and family contributions they can receive. So whereas in 2016, for example, a clean candidate might have been able to take the $180 in seed money from an aunt without having that go towards their seed money, their personal money cap. Under this rule, it will. And that is, we believe, or at least I believe, a result of the litigation in a case called, I think it's called Arizona Advocacy Network versus State. So that's what we've done. Those definitions will line up with the statute. There is, and I'd be remiss to not say that there is a crimping on donations that would have been available to participating candidates. And there is a crimping on the right of those persons who are under that definition to give to the candidate of their choice if they are participating. Those are results of the statutory change, and those will be results of the rule change. However, this is not a policy. In my view, this is not a policy discussion. It's a legal exercise. So we recommend that the Commission approve the rule, and we will then forward it to the Governor's Regulatory Review Council.
Thank you, Tom. Any questions from the Commission? Okay. If there are no questions, is there a motion to approve the rule, proposed rule? Or an amendment to the rule, I should say.
Madam Chair,
Commissioner Kimball?
I move that we approve the amendment to R2-20-101, the rule amendment related to personal and family contributions to candidates participating in the Clean Elections Funding Program.
Thank you. Do I have a second? Oh, thank you, Commissioner Meyer. I heard you second that. And we do have a motion and a second, so I will call the roll. Commissioner Meyer, how do you vote?
Aye.
Commissioner Kimball, how do you vote?
Aye.
And I vote aye as well. By your votes of 3 ayes and 0 nays, we have approved the amendment to the rule. All right, moving on to item 6, discussion and possible action on MUR 21-01, the Power of Fives LLC. The Commission may choose to go into executive session for discussion or consultation with its attorneys. This is an enforcement related item that I continued from last month. There was a lot of discussion around that. And since I'll have Tom introduce the item, give an overview of his recommendation, and then have time for commission questions and discussion. And then following that, we can hear from Mr. Lasota, the attorney for Power of Fives. Tom?
Madam Chair, Commissioners, thank you. I want to say, ordinarily we haven't done timing on these things, and I'm not saying we should, but I do want to make clear that we are going to we would like time for rebuttal after Mr. Lasota presents. So where we left things last month, really the upshot of the what amounts to a motion to dismiss from the Power Fives is that there is there's a bright line to be found in the Clean Elections Act between a business and everything else, and I think that that's a good place to start, because I think the big picture here is that, and I should note, my colleague in this case, Kara Carlson and Kyle Cummings are here, and I will at some point they will have their own thoughts to add, I think. But I think that's a good place to start, and I think that I think the Act makes it clear that that's what we're recommending is, as far as determining there is reason to believe here, is appropriate. Voters in the findings and declarations of the Clean Elections Act, voters talk about the influence of money on elections. They talk about the need to have more information about how candidates are funding their campaigns, and it seems to me that when you read those findings and declarations, it's pretty much impossible for me to conclude that voters intended to create an on-ramp for a network of undisclosed campaign finance activity. Because as the complaint indicates, this is not, the Power Fives activity here in the main arises from activities with Mr. Sloan, but there were several other candidates who had this same relationship with the Power Fives. The Act, by its terms, applies to persons. It doesn't apply expressly to candidates. 16957, the penalty enforcement provisions expressly apply to anyone who violates the Act. It's been the Commission's position, in fact, in court throughout every case, that it has jurisdiction to enforce the Act across a variety of different kinds of entities that come in conflict with the Clean Elections Act. And every court that has ever looked at the jurisdictional question of the Commission has essentially concluded that the Commission has the jurisdiction that it asserts under the plain terms of the Act. I think that one of the things that so we talk about, like, what would be the reasons why there could not be reason to believe here. And again, I think that the main one has always seemed to be, well, we're a business. Now, in this particular case, the complaint makes clear that whatever the Power of Fives was doing, it resulted in a campaign finance activity that ought to have been reported and wasn't reported. Campaign finance activity that implicates and directly involves contributions or items that are either contributions or expenditures on behalf of candidates by the Power Five. And so, just to underscore the audacity of the Power Five's response in this matter, it's illegal for limited liability companies and corporations to contribute to candidates. So, does the Campaign Finance Code apply to businesses? Absolutely. It absolutely says that businesses have to be more careful in how they interact with candidates under the code than anyone else. The only exception under the campaign finance code for all of these things is for entities that have designation under section 501A of the Internal Revenue Code. Nothing else. And that's not a fact here. The contours of that don't even matter for this purposes, but in this case, there's no exception. So I think that we've made out the prima facie case here for the violations that are laid out in the complaint. And for that reason, we recommend that the commission determine that there's reason to believe here. And, so that's really our position. Kara, I don't know if you want to jump in here briefly.
Yeah. Thank you, Madam Chair, Commissioners, and Tom. Thank you for giving that initial kind of table setting perspective. Because I drafted the slides about the reporting period, I wanted to kind of explain why I provided that, and then especially since Mr. Sloan is here also separately, I did want to highlight for the commission that while the facts that I included in here are related to the Sloan campaign, that is only because those are the facts that we have directly from the Power of Five. So we are using what should be undisputed facts provided by the Power of Fives that give an example of what the Power of Fives scheme, their contractual scheme, would allow them to do with any candidate. So, to the extent that this appears to be, I just don't want it to be interpreted as an attack on Mr. Sloan, because this is the information that we have that was provided from the Power of Fives. So the Power of Fives acknowledged that work began in August of 2019. The Power of Fives stated that they spent money on Mr. Sloan's campaign beginning in September of 2019. They purchased signatures, they booked events. So they spent some kind of money on at least Mr. Sloan's campaign beginning on September 2019. They booked, or they signed the contract on January 2020. And the first, at the latest, the first campaign finance report would have been due April 15th. There was no campaign finance report. And in fact, that is not an accident. That would be, under the Power Fives thought process, that is exactly how it should work, because even though the Power Fives was out there making expenditures on behalf of getting Sloan elected, Sloan hadn't made those expenditures. And then moving to the second reporting period, you have Dr. Branch hiring Mr. Lasota and paying to both defend Mr. Sloan's petitions and to knock off Mr. Sloan's competition. Again, nowhere is that disclosed that happened. By June 18th, you have the Branch email to the state committee for the $5 contributions for the Power Five candidates. And I think, and then you have this like very rushed period in July where the actual qualification happens, money is changing hands, and the final invoices for all three phases are sent, and there's a cancellation. But basically, like, what that shows you is that from September of 2019 through July 25th, 2020, under Dr. Branch's reading of the Clean Elections Act, no reporting is required for a full year. They can do a full year of work and no reporting is required. If you take their perspective. And then I think obviously the big issue, or at least an example, a single example from what we have right now before we've been authorized to do any further investigation is that June 18th email, where Dr. Branch sends out an email requesting $5 contributions for Mr. Sloan's campaign. And nowhere in that email is there any explanation that if he's successful in qualifying Eric Sloan, that is a direct benefit to Dr. Branch. Dr. Branch is sending out this email on behalf of a campaign, but he doesn't admit it in the email. And there's no report indicating that should Mr. Sloan qualify, he will actually stand to benefit at least $116,000. Now, I have a hard time looking at the act itself and figuring out a way where that does not violate the act. And I do repeat Tom's point that under 916 LLCs shall not make contributions to candidate committees. We know that Dr. Branch, by his own admission, paid for $23,000 in legal fees. So this is just the tip of the iceberg in what is going on. But really, the key point of this slide is to just show you some highlights of like these are big ticket things that happened, and that would go unreported because of if we accept the Power Five's reading on this.
So may I ask a question of Kara before we throw it back to Tom? I mean, and these slides were very helpful, Kara. So thank you. I wasn't sure who created it. It reminds me of the conversation we had last month when it was Commissioner Payton, Commissioner Kimball, and I. And I think my discomfort with this is, why is it not on the candidate to be the reporter? Why are we putting the onus on the consultant? Are we going to have a situation now if we go forward with this just seems so different from things we've done in the past. And I don't know if I'm missing something. If I'm wrong about that, please call me on it. I think of Constantine Carrard, who I just happen to know as a consultant who, I don't know if he still does, but has represented a lot of clean elections candidates in the past. Is he going to have to register as a political committee as a consultant? Okay, so I see Kara shaking her head. I know Tom has his hand up too. Kara, let you answer first, and then Tom, you can have your say as well. Because those were my concerns last time is, are we going down a path that is, to my mind, a little, not a path I'm comfortable with. Go ahead.
No, I hear your concern. This is different this is not saying that the LLC, that a campaign consultant would be on the hook for making the making the record, filing the reports. What this is saying is you cannot set up a business system that by its very nature avoids needing those reports, right? So the argument that Sloan is making is, or not that Sloan, excuse me, the argument that Branch is making, to the best of my understanding, and obviously Mr. Lasota will get an opportunity to rebut this, is that we're fine because we just made this business and no one owed money until this later point in time, even though all of these transactions were taking place beforehand. And that is a clear violation of the law, especially when you get into the fact that, again, by its very terms, 16916, LLCs cannot make contributions to a candidate committee. And this was either a contribution to a candidate committee because, if Mr. Sloan didn't qualify, then he would not owe them anything, in which case the LLC has given all of this money to influence an election. Or he intended to make that money all along, and this was set up expressly to avoid any kind of the regular disclosure obligations.
I mean, I agree with you on a promise to spend, a contract like that needs to be reported at the time it's entered into, right? I mean, and I think I brought up the Napolitano campaign from years ago, running into this exact problem. But again, like at that time, it wasn't her consultant, it was her campaign that was in trouble for that. And I think Mr. Sloan had his own issue with us regarding this matter. And perhaps I'm just too dense for this, but what is it that makes this Branch's issue rather than Sloan's issue? And again, not to beat up on Mr. Sloan here. Tom, did you want to jump on that one, or?
Yes, I absolutely
And
do.
I apologize.
It is both of their issue.
Okay.
We have an enforcement going against Mr. Sloan. It's on the agenda later. Mr. Sloan's requested it to be there.
Yes.
This enforcement, when we brought this case to the commission a year ago, the commission told us, go out and figure out what's happening here. We have a he said situation. It happened in this very Zoom room. And what we did was went out and dug into the facts. We have the facts. We have all the facts we thought we could appropriately have before we had to file a complaint. And then we did that. The reason why the consultant is on the hook here too is because under the statute and the rules, the consultant is an actor in his own way. Not every consultant is doing this way. I have no evidence or experience of anyone ever having a business set up where you could agree to provide services, begin to provide services, and that services, by virtue of the contract, evade the very rules that are in place. So if the commission does not have the authority to put accountability on everyone who may have, again, this is a reason to believe stage. This is not the end of this case, with all due respect, Chairperson Chan. If the commission says that now, there will be an exception that will allow consultants to drain the Clean Elections Fund with no accountability to the public whatsoever. And I simply can't read the Clean Elections Act to say that.
Okay. Thank you, Tom. Thank you. Anyone? And I interrupted, I think, because you had given it over to Kara, and then okay.
I think we're okay for now. I mean, we obviously want the time to rebut.
Yes.
It's important.
Sure.
So, thank you.
Okay. Any commissioners have any questions so far other than myself? And if not, we'll move on, I think, to Mr. Lasota, if he's ready and willing to speak up.
I am. Are you ready for me to begin, Madam Chair?
Yes, please go ahead.
Well, good morning. I'm Timothy Lasota on behalf of the Power of Five. And so I'd like to start by talking out there are two separate issues here. I think either one would command a decision to dismiss this matter, but there are two issues. There's the issue of Mr. Collins trying to regulate a vendor, which the chair has talked about at some length at both, and I think raised all the right questions that I'll get into further in a moment. But there's that issue, and there's also the issue that, look, at the inception of this contract, there's no promise, agreement, no obligation to pay anything. But I'll get into that second. First, I want to focus on the notion that now vendors have to register as political committees. And Mr. Collins is wrong that nobody has these types of arrangements. And I'll give you a good example. I mean, so, we talked about last time. Last time, Mr. Collins said the Power of Fives is set up to to influence elections. I said, no, it's not. It's set up to make money, same as my law firm. But what if I'm in a situation, and in these election cases, they happen very quickly, payment is not made until later. And sometimes payment's not made at all. Believe it or not, candidates have been known to stiff an attorney. So in that case, I've now made an in-kind contribution to the candidate, and now, according to Mr. Collins and Ms. Carlson, apparently, I'm now guilty of not just violation of the Elections Commission Act, but I'm now guilty of a criminal offense because my firm is it's an S corporation. So, I mean, that's the path you're going down. Absolutely. I'd like to answer that question for the chairwoman. If you side with Mr. Collins and Ms. Carlson, absolutely, I will tell clients that they need to register as a political committee, because what if they get caught in the situation, where somebody doesn't pay a bill? In that case, they are in no different position than the power of fives. Sometimes people take things on a contingency. I don't see any reason why that wouldn't be legal, generally speaking, in this realm. Well, now it's illegal. And now, and never mind the Clean Elections Act, but just look at corporate, let's just look at the corporate contributions prohibition. Now, according to Mr. Collins and Ms. Carlson, that would be a criminal offense, because you've given something of value as soon as you've entered into that agreement. So this is a very troubling path for the commission to lead down. And this business about this is just at the reason to believe stage. Look, we're here with a legal issue now. There's no reason for this commission to proceed with this matter, because there's really no need for further investigation. It's the legal issue presented to you. I think that the chair has focused very appropriately on the terrible precedent that would be set by if we're going to credit Mr. Collins and his Ms. Carlson here. But let's get into some specifics here as to why Mr. Collins and Ms. Carlson are wrong. So let's just talk. They keep talking about attorney's fees, and you'll notice they never read anything from the statute. Okay, so let's look at the statute. So we're talking about exemption from the definition of expenditures. The following are not expenditures. The value of any of the following to a committee: payment of a committee's legal or accounting expenses. Anyone can look that up under 16-921. 16-911 is exemption from definition of contribution, says the exact same thing. And this is exactly what Mr. Collins lost. This issue he lost in his Arizona Advocacy Network case, where he said the legislature cannot change that statute because it is locked in by the Voter Protection Act. So, obviously, Mr. Collins, doesn't like things that take certain elements out of his regulatory purview. I guess maybe technically he was a defendant there, but it was one of those where he was on the side of the plaintiff. And they were advocating that the legislature cannot make that exception for legal fees. Well, they lost. And it's right there in statute. So I have no idea why they keep talking about that. Also, I have no idea why they keep talking about 16-946. That's the qualifying contribution statute, where you continue to hear Mr. Collins and now Ms. Carlson joining him saying that Mr. Branch violated that statute. Well, let's read that actual statute. It says, during the qualifying period, a participating candidate may collect qualifying contributions, which shall be paid to the fund. To qualify as a contribution must be, and it lists the different things that a contribution must be. It does not say anything about, about that there's a violation of that statute. What it says is if that statute is not followed, a contribution is not a qualifying contribution. I mean, it stuns me that we would have repeatedly these either misunderstandings or misstatements about clear statutory law that anyone can go look up. 16-946. You notice you really didn't hear any quotations of the actual statutes, because they keep trying to get away from the actual laws. So And there is there's actually a criminal penalty that would apply to somebody but it only as to 16-946, but it only applies to somebody who actually pays for a contribution. It doesn't apply to any of this other business, a solicitation that they allege was improperly sent. So obviously the drafters thought of that and did not include, any sanction for not following that statute, except in that one limited case. Except the only sanction is the contribution does not count as a qualifying contribution, but you can't, it's not a violation of the statute unless you're paying somebody for the $5 contribution. So now in terms of, we talked about at some length, I put this in my memo that, look, the bottom line here is that at the inception of this contract, there is no promise, agreement, contract, or otherwise an obligation to pay for goods or services. It's entirely contingent. As of that moment, none of those things exist. And that's why, you heard Ms. Carlson make a huge concession when she spoke. She said the word if. That was the word she used, if. And that's the critical word here. It's an if, and Mr. Collins says he can't read the statute that way. Well, I mean, he doesn't want to read it that way, but that's what the statute says. And when we don't like, and okay, let's just, maybe someone could argue that this is a gap, right? That somehow this situation was not intended to be not addressed, and sort of the situation that Ms. Carlson talked at length about prevails, where somebody is allowed to do this, and if the person doesn't qualify, the thing just kind of disappears. It poof. Well, let's say that was an oversight. I don't know that it was, but even if it was, the proper response to that is to address the oversight through legislation. It is not to read out or contort the words of the actual statute. So, the bottom line is there's nothing, at the inception of this thing, there's no promise, there's no agreement, there's no contract, there's no nothing for an obligation as of that moment. The obligation arises later, and if at all, it's contingent. It may not arise. If X doesn't happen, there is absolutely no obligation. So how can you possibly say there's an obligation at that moment? You can't. There is an obligation that may or may not exist in the future is not an obligation, period, end of story. So the bottom line here is, that there are two separate reasons. Both of them are good enough. There's no reason for this matter to proceed any further, because the commission is at the threshold of what's really a legal determination, and that does not involve. That doesn't mean we need to give Mr. Collins more time to investigate. He's had plenty of time. Most of the things that have come out have come out in that other civil matter. But, the bottom line here is look, if we're going to go down this path, I mean, I don't know what it's going to do to this entire industry. But people like me, it's like I said about my law firm. My law firm was formed to make money. That's why it was formed. I mean, yeah, sure, I help candidates, but campaigns are formed to win elections, and vendors operate to make money. Now, they make money by helping candidates win elections, but it does not mean, as Ms. Carlson and Mr. Collins would have it, that every one of those needs to register as a political committee, or that this commission should embrace that, what I view as a very chilling, very problematic step. And you notice, their attempts to say, well, what's the difference? The chair asked, well, does this mean that everyone needs to register? And they said no, but they never said why not. Well, of course they need to register. What if I help out a candidate and the candidate stiffs me? Now I should have registered, because I should have said at that moment, I've made an in-kind contribution to the candidate, even though that was, I never thought I'd be in that position. It's really, it may not be the exact same situation as the power of fives, but that conclusion is inescapable if you go down the path of trying to regulate vendors. Now, the last thing I'll say is if the Clean Elections Act was meant to so clearly to apply to vendors and entities that simply assist for a living, that's what they do, that's their trade, the Constantine Carrards of the world. If it was meant to apply to that, where are the penalty provisions? Now, Mr. Collins said, oh yeah, we've got that authority and it says we can do this, it says we can do that, it says any person. Well, okay, then how come he still has not identified what the penalty would be, what penalty this commission would be able to impose? So I looked through, I think the penalty provisions are 16-941-940 to 943. And I don't find anything that would be even remotely applicable. 19 I'll pull up 941 real quick. That talks about well, 941 limits on spending and contributions for political campaigns. That says that A is a participating candidate, B is a non-participating candidate, C is a candidate, whether participating or non-participating. So, that's it. And then there's also, there's 16-942, that the reporting obligations that may arise under Article 1 are certainly not the purview of this commission. Under 942, they talk about the civil penalty for the participating candidate. It's 10 times. There's forfeitures of office. Criminal violations and penalties under 16-943. Candidate who violates 941, class 1 misdemeanor, that's not us. Any person who knowingly pays anything of value or compensation for a qualifying contribution, a class 1 misdemeanor, that's the one thing that would make an actual violation of 16-946 subject to a sanction other than that the qualifying contribution doesn't count. Not applicable, false or incomplete report, class 1 misdemeanor. So, I mean, what would you do to the power of fives? I put that in my memo. We still don't really have an answer on that. And if it's so apparent that the drafters, the voters intended to capture us, then why is that? Why aren't there actual penalty provisions that seem to apply to a vendor? So with that, I'd be happy to answer any questions.
All right, and just real quick, Tim, I want to come to the defense of, because I feel a little bit like you were casting some aspersions on Kara and Tom, and I disagree with that entirely. I mean, they are two of the best lawyers I know in the election realm. They know their stuff. I think they don't speak down to the commission or the public. So not reading out the law is not, they're not hiding anything. I know that there are sincere disagreements here, and I know you and I have had them before too in the enforcement realm. I think back when I was at the Secretary of State. So, we can all have disagreements and reasonable disagreements even. And I don't want to have that be on the record without speaking up about that, because they're two probably of the attorneys that I probably respect most in Arizona on our election laws. So I do want to say that.
Well, can I address that, Madam Chair?
Sure.
I like Mr. Collins and I like Ms. Carlson. I mean, Mr. Collins actually sent me a client. And it doesn't, and I think they are trying to get you, they're not doing, they're advocating. And
just like you are, any good attorney is going to advocate on behalf of their client and how they see the law.
I don't blame them for that, but look, if you've got a statute where you'd rather characterize the statute in a certain way. I mean, I do the same thing. That's not a character aspersion, but I'm trying to get you back to the actual wording of the statute. And naturally, they're maybe trying to get you a little bit away, but I didn't say that's anything I wouldn't do under similar circumstances.
Well, thank you for that clarification. I wanted it to go on the record that knowing them both the way that I do and how much they, and I know yourself too, you know the election laws in the state as well, but they are two of the most knowledgeable election attorneys I know and have such personal and professional integrity. So I just wanted to recognize that for everybody and have it on the record. I don't know what the best order to go into is. I know Tom wanted to speak. Did Mr. Sloan want to speak as well? Okay. Tom, do you think we should allow Mr. Sloan to speak? I don't know if it matters to you one way or the other, but.
It certainly doesn't matter to me. If it's a procedural question, I would defer to Ms. Cody.
Okay, well, I'll perhaps let Mr. Sloan speak, and that way you can kind of wrap up, maybe make your summation, so to speak, after that. So I'll recognize Mr. Sloan.
Thank you, Madam Chair, members of the commission. Well, this has been going on for quite some time. Here we are a year later, a year and a half later, actually, since this issue originally arose. I will be speaking later on to the other item regarding myself as a candidate, but I think it's really important to point out some things. Mr. Lasota made the point that there's no promise to pay until you're qualified. And that was how the contract was explained to me by Dr. Branch. There were only 17 days between the moment that I fired Dr. Branch, or the moment I qualified, and the moment that I fired Dr. Branch. So there were 17 days there. So he's asking for $116,000, the entire amount of the clean elections funding for that 17-day period. That's the first issue I want to point out to the commission. The second point that I want to point out to the commission is that Bob Branch weaponized this commission against a former client of his because I raised issues about the legality of the contract. And once I raised those issues about the legality of the contract and brought those issues to the commission, which Mr. Collins and Ms. Carlson can confirm to you, and was told that the contract did not apply to clean elections, did not meet the standards of clean elections law. At that point, we tried to figure out what we needed to do, and I worked hand in hand with the commission on what needed to be done, which included withholding $94,000 of disputed revenues, which were returned to the commission promptly within hours of a repayment order being paid. I also want to point out that it is my understanding, it has always been my understanding, that you cannot use clean elections funds to pay legal expenses. So the argument that this would cover all vendors, including law firms, is a big stretch when you're looking at the actual wording of the law. Part of this issue arose because Dr. Branch asserted and has continued to assert that he spent a lot of money on my behalf without my knowledge before I qualified for clean elections. That was never disclosed to me as a candidate. My understanding was always that once you qualify, the obligation begins, as was stated by Mr. Lasota. So that's the entirely, the other part I would point out is that the commission has found on numerous occasions that the Power of Fives and Dr. Branch's accounting makes it impossible for a candidate to do the appropriate filings, not only with the Clean Elections Commission, but with the Secretary of State's office. That is done purposely by the Power of Fives, because what they are doing is trying to take all of that money and then not provide any service, which is the reason why we are in this situation now, because I became aware of what they were doing and decided that I was not going to be a part of that. Again, I just want to point out that I am in the middle of a civil matter with the Power of Fives. They have sued my wife and I personally for these monies. We have accrued a tremendous amount of legal expense to defend ourselves. We have lost the arbitration. The arbitrator, the Power Fives is now trying to confirm the arbitration award, which is $116,000 plus another $60,000 or $70,000 in legal fees against me and my wife personally. The judge in that case is waiting to see what the outcome is with regards to how the Clean Elections Law actually applies to this contract, because Dr. Branch has sued you all with regards to that. But more importantly, I think it would be really important that we continue to move forward with an investigation, because there are more things to be uncovered. There were other candidates who were involved who qualified for clean elections. There are current candidates that are being solicited by Dr. Branch. He is continuing to use this model, and quite frankly, is continuing to defraud people by telling them that he is in compliance with clean elections and that he is an expert in clean elections. The Power of Fives denotes his expert status of clean elections. His contract reads that he is an expert in clean elections, and yet he is putting candidates like myself and others in a position that we could be fined up to 10 times the amount of the contract, which we entered into in good faith, but he did not, because he has put us in a position where he can extort us by filing a complaint with clean elections if we don't pay him. And that is wrong. And the commission should absolutely investigate that. Thank you, Madam Chair.
Thank you, Mr. Sloan. All right, Tom?
Yes, Madam Chair, Commissioners, look, just to try to briefly rebut some of the points that the Power Fives raised. The Power Fives admitted right here just now that they spent money on the candidacy of Mr. Sloan and didn't report it anywhere. Under the Act, spending on behalf of a candidate under 16942B must be reported. It was not. The
And
issue,
Tom,
yes, I'm sorry.
that
yes.
is the difference. What that you're is that, and I'm sorry to keep beating on this. Probably maybe
That
you
is
wish it
that
was
is
difference, but
that
that
is
is the difference
that
between.
is a difference.
Okay.
That is a difference for sure. If you're looking for statutory language, it's all, this is all in the complaint, mind you, but and
Right.
the response. But I mean, so just to make a point for the record, in fact, every citation necessary for this is in the materials, and we assume the commission has read those materials. So we didn't feel the need to do a PowerPoint with a bunch of citations. But yes, the Act penalty provisions expressly apply to spending on behalf of a candidate must be reported. It wasn't here. Mr. Lasota doesn't dispute the fact that Tower Five went out and spent money on the candidate. There is a dispute about whether or not that spending was authorized or known or not. That's what we're trying to get to. That's part of the reason why we think there is good jurisdiction here. With respect to this idea that if someone stiffs you on a loan, you somehow accidentally made a campaign contribution, the statute deals with that. 16921 expressly talks about the fact that if you have an extension of credit, it has to be commercially reasonable, and you have to do something to go and get it back. If you waive that loan in an unreasonable way, yes, you have in fact made a contribution. That's black letter law. So the law is, the law is clear. There are, and the admissions are clear. The Power Fives went out and spent money. Mr. Lasota confirmed that again here today. That money was not reported in a timely manner. The details of those reports would not have been, at least for purposes of this motion, enough to satisfy the requirements of the Act in terms of reporting as it is. Those are, in fact, actions that the Power Fives took. Mr. Sloan took actions. Those are subject to another complaint. Those are actions the Power Five took. The Power Five admitted them here today. In fact, Mr. Lasota's defense to this very complaint is that they went out and spent money on the campaign and didn't report it. That's the defense. That can't be a good defense. It wouldn't matter if they were a PAC or a 501c4 or whatever. If you are spending on behalf of a candidate, You have reporting obligations under the Act that are freestanding and independent of everything else in the Campaign Finance Code. So at a minimum, the prima facie case for reason to believe is made. And if we don't think that prima facie case for reason to believe has been made here, then we are in fact reading out the on behalf of language in 16942B. We are reading out the commercially reasonable requirements under the regular Campaign Finance Code. We are reading out the fact that the Commission has a specific rule that binds agents in this particular context to avoid this very kind of activity. Mr. Branch and the Power Fives know the Clean Elections Act. They say they know the Clean Elections Act. Now, I have no doubt that Mr. Lasota knows the Clean Elections Act. Mr. Lasota is true. Mr. Lasota is an excellent attorney, and I believe very strongly that he makes some good arguments in some cases. Here, that's not this case. There's no slippery slope here. There's no nothing. This is a discrete set of facts where an LLC's lawyer comes before the commission and says, yeah, we went out and spent on behalf of the candidate, and no, we didn't report it. And that's really all there is to this stage.
All right. Thank you, Tom. I'm not sure if any members of the public wish to weigh in. If so, let me know by raising your hand or unmuting and speaking up. And do the commissioners have any comments or questions? Oh, I'm sorry, Kara. Commissioner Meyer, you have a comment or question? Perhaps I'll let you go and then Kara can.
Thank you, Madam Chair. I do have a question, and I was not at the October meeting, so I apologize if I'm asking a question that's been answered. I didn't see a copy of the contract in the materials for this meeting. Is that in there anywhere?
I think we might have.
Yeah, it was on a link. So there was a link with the Google Drive that had.
Okay, my apologies. I guess so. My question is, when what we're essentially talking about is a contingent liability. What is the event that happens to make that contingent liability then become a fixed liability? That when the party of five actually is owed money, what event happens to make that the case? And go ahead.
Mr. Lasota? I assume that's for Mr. Lasota.
Yeah, that's for anyone who knows the answer.
No, I could address that, and it's the qualifying. And as a matter of fact, in the arbitration by Judge Albrecht, the former Superior Court judge, she found, and I'm going to quote, "This contract was for the Power Fives to provide campaign consulting services. Provide campaign consulting services is not illegal, even if the candidate wants to be or is a clean elections candidate. The agreement did not bind the campaign to a specific obligation. There was no debt created for the campaign by entering into the agreement. There was no obligation to pay until/if Sloan qualified for public financing. There's nothing in the clean election laws and regulations that prevent a candidate from entering into a contract for services before he receives clean elections funding, with the payment to be paid upon receipt of the clean elections funding." That's exactly this issue, and it is upon qualification. And yeah.
And my next question relates to the penalty issue that Mr. DeSoto raised. And Tom, is the penalty here 942B? Is that where the penalty is, or for the party of fives?
Well, Madam Chair, Commissioner Meyer, I think that Mr. DeSoto confirmed that. In fact, that based on what Judge Albrecht said, if the candidate didn't owe anything until qualification, then all of the expenses that were incurred by the party of fives were incurred on behalf of Mr. Sloan and unreported. And those are, in fact, required to be reported under 16942B.
No, I understand that's the offense, but what's the penalty?
Well, the penalty would be that they would have to file those reports, and they would owe a late fee of up to twice the amount of the unreported expenditure.
Okay. So that's the B then, right? That's the source.
Oh, Mr. Lasota apparently disagrees with that. He's shaking his head.
And I really appreciate the opportunity. So let's read B. In addition to any other penalties imposed by law, the civil penalty for a violation by or on behalf of any candidate or any reporting requirement imposed by this chapter shall be $100 per day for candidates for the legislature and $300 per day for candidates for statewide office. I mean, there you go. Again, another example of the act penalizing candidates.
I'm sorry. I'm sorry.
I'll let Tom speak, but to me, that means that's the race involved, not the candidate specifically. Maybe I'm wrong about that.
Madam Chair, this is very important. We have a
Please.
case pending at the Court of Appeals right now where our position is the precise opposite of that. We are, I just have to advise you and advocate at this point, not advise, advocate here that this commission's position has been, and we are in court right now with the position that 942B's language says precisely, Madam Chair, what you just said. This is not fooling around stuff.
Well, and
Okay, go ahead,
Madam
Kara.
Chair and Commissioners, if I can also add that in terms of statutory, reference, 169017 defines candidate to include not only the person running, but also anyone who is receiving contributions or making expenditures on behalf of that individual in connection with the candidate's nomination, election, or retention of office. And I just wanted to say, Chairwoman Chan, thank you for making that statement. We were not running from the statutes. We did not need to cite this. We have 9 pages of documents that include lots of citations. To the extent you need any additional elucidation, we would be happy to do that. But it was certainly not meant to be running and or hiding from the statutes. It was just to not beat you over the head with what you've already received.
Thank you. And I see Eric Sloan has his hand raised. Yes, Mr. Sloan.
Thank you, Madam Chair. Mr. Meyer, or Commissioner Meyer, the way it was described to me by the Power Fives and the way Mr. Lasota has described it today is that the obligation begins once you receive funding, okay? The way that it was described to me by the commission staff was that once you enter into an agreement, the promise of the agreement is the actual, I'm sorry, I'm not a lawyer, so I'm trying to put these words together here, is the actual qualifying moment that happens going forward. So there was a big difference there, okay, which is the reason why. I'm sorry, again?
I'm sorry, and especially to our court reporter, but the obligation that you enter into before any money changes hands is something that needs to be reported. I agree with that. I believe that is the law.
Yeah, and I believe that there's statute there. I can't cite the statute because, again, I apologize. I don't have it in front of me and I'm not a lawyer. But that was the issue at hand. With regards to the arbitrator said there are 4 corners to this contract. And because there are 4 corners to this contract, Mr. Sloan has to pay Power Fives. She did say that there could be, and I don't have it in front of me again, but there could be an issue with regards to clean elections law. But as far as a contract goes, this is a contract, right? She didn't take into account clean elections law. Now, I think to a large degree, being a part of that proceeding, she didn't understand it. And Dr. Branch made it very clear that arbitration was specifically about a contract between himself and me as an individual, which I did not sign that contract as an individual. I signed it as a candidate, which is the reason why we're here today. And I just think it's really a bad situation that an arbitrator who didn't understand clean elections has passed a ruling that is now going to put the entire system in jeopardy. The system will no longer exist in its current form if this is allowed to happen. And the only way you're going to get to the bottom of this is if you dig into it and investigate it. So I would again encourage the commission to investigate this matter. Thank you.
Thank you, Mr. Sloan. And I will say from my perspective, although the arbitration decision can be illuminating, I do view it as separate from the election law issues. I mean, it may be relevant or helpful in some way, but to me, it's not dispositive as to the election or campaign finance issues for the reasons you stated. Well, I think if there's no other, oh, I'm sorry, did I miss anybody?
More seconds. Going back to 16-942B, where we were talking about recording the language, the last sentence of that subsection says, the candidate and the candidate's campaign account shall be jointly and severally responsible for any penalty imposed pursuant to this subsection. So I think clearly that's a penalty provision for candidates.
Okay, and I think now I see.
But what happens, Madam Chair, I'm sorry, I didn't mean to interrupt, but what happens when you have a situation where a consultant spends money or says they spent money on behalf of a candidate without candidate ever being informed or told that that was happening, and then dropped a bill on the desk that says, pay me $116,000 for 17 days of work. And oh, by the way, it wasn't 17 days of work. We started work back in August. I mean, he could make up any mythical date that he wanted and use it. What Bob Branch has done and DePower 5 has done is they've tried to have it both ways in this case. Now they're saying, well, there's nothing wrong with our contract, but also Eric Sloan owes me all this money. And if he can't pay for it out of clean elections, he just has to pay for it out of his own pocket. It's preposterous.
Okay, thank you, Mr. Sloan.
Thank you.
I'm gonna put a pin in the conversation now because I think I've heard enough to move forward. I feel more comfortable now. I know I've made staff aware just from my statements here, the concern I have about, but I think I understand it a little better now. I have a little more comfort with it. I definitely agree on the law regarding the obligation. That's where you start the obligation to report, not the actual getting the money and changing hands. Does that make sense? So for myself, I think I'm comfortable moving forward. I want to make sure the other commissioners are as well. Unless you guys have any questions, I will entertain a motion to approve the recommendation memo set forth in the materials, or a motion to determine there's no reason to believe. So does one of you want to make a motion?
Madam Chair,
Yes, Commissioner Kimball.
I move that we authorize Tom to move ahead as, let me make sure I have the wording correctly.
To approve the recommendation memo?
To approve the recommendation and move ahead with a determine that we believe that there's reason to believe violations of the Clean Act and rules may have occurred.
Thank you. Is there a second?
Just so we're on the same page, can I get that motion one more time? Can I hear that again?
Sure. Do you want to restate it, Commissioner Kimball? I think you can say motion to approve the recommendation memo set forth in the materials.
I would recommend that the motion does include the reason to believe language.
Oh,
and also,
well done, Commissioner Kimball.
I was so pleased. I'm so impressed. And also recommend that the motion would include both the complaint and the reason to believe memorandum, because the complaint does specify the statutes in more detail, as Ms. Carlson had mentioned. So perhaps a motion along the lines of, move to proceed with an investigation, commission finds reason to believe violations of the statutes or rules may have occurred based on the complaint and the reason to believe memorandums provided, something along those lines.
Commissioner Kimball.
Madam Chair, can I just cut and paste what Ms. Cody said as my motion?
Yes. Okay. So we have a motion. And do we have a second?
I second. Commissioner Meyer, I second it.
Thank you. And we'll go ahead and have our vote. Commissioner Meyer, how do you vote?
Aye.
Commissioner Kimball?
Aye.
And I vote aye as well. I appreciate the staff and Mr. Lasota and Mr. Sloan explaining all of this to me. I feel like I've been a little bit of a logjam with, my difficulty, but I do believe that there is reason to believe here, and that's why I did vote aye. And so with our votes of 3 ayes and 0 nays, we have approved that as moved, and we'll move on to the next item, item 7. I did want to ask our court reporter, do you need a break? We have a few items left, and I wondered if you could use a brief break.
I'm okay to keep going if everyone else is. Thank you for checking.
Okay, sure. All right. Everyone else good to keep going? We'll just try to move it along. All right, item 7, discussion and possible action on MUR 20-04, Eric Sloan. This item concerns a complaint brought by Dr. Bob Branch of the Power of Fives against Eric Sloan, who is a Corporation Commission candidate. The commission determined reason to believe last December and entered a repayment order in April that Mr. Sloan fulfilled. He has requested to address the commission regarding this matter, and we may close the matter or take no action. Staff has not proceeded to the next stage in MUR 20-04, but is available to answer questions. So with that, I'll allow Mr. Sloan to speak to this, and then if the commissioners have any questions or comments, perhaps Tom can step in.
Sorry, I hit my camera button there instead of the mute button.
Oh, that's all right.
Well, let me see where to begin. A brief historical background. I was a Power Fives candidate. My signatures were actually challenged by Bob Branch's attorneys, his legal counsel for his Power Fives corporation. That began to sour our relationship. Subsequently, I did hire Tim Lasota, who was on this call representing Bob Branch. Tim Lasota represented me in court. He was my attorney. He candidly never disclosed that Bob Branch was his client. I was always under the assumption that I was his client. I found this out that Bob Branch was his client in the newspaper of all places in November during the last election cycle. The issues that arose between me and Dr. Branch arose specifically around his billing practices and the fact that he was trying to bill me for things that he never did. And he was trying to bill me for things that he couldn't possibly do. As example, printing services. He also had made several comments, and I believe the commission has these documents, where he said that that money was not the campaign's money. It was his money to spend as he saw fit. At that point, I contacted Lee Miller, who I had met during the campaign, who is a elections attorney. I believe Lee spoke directly with Tom and Kara regarding the situation. We fully disclosed every single thing that was going on. I have done nothing to prevent the commission from having full access and full disclosure with regards to my campaign. I have admitted that I entered into a contract, which I believed was legal at the time that I entered into it, but subsequently was notified by clean election staff that it was not compliant with clean elections law. At that point, I put a full stop on all monies and payments to Bob Branch and withheld that money. It was about $94,000. The commission did agree that there were $23,000 in justifiable expenses after I fired the Power of Fives and Dr. Branch. As I stated before, there were 17 days between my qualifying and Dr. Branch being fired, Power of Fives being fired. There was actually 30 days between the time that I got the check and my canceling the contract with Dr. Branch. But I understand that the qualifying is the issue, not the actual receipt of the check. I have fully admitted to my fault in this. As I said before, I am being sued civilly. My wife and I personally are being sued by the Power of Fives. I did not enter into that contract as an individual. I entered into it as a candidate. There are several lawyers on the call, so I'm sure everyone can make the distinction there. This investigation is being used as a weapon against me in the civil matter. It's being used to tell people who are decision makers, who don't understand the clean elections process, who don't understand the administrative law side of state agencies, that I am under investigation for acting improperly, when I think I have clearly stated here and continue to state in my civil matter that I was defrauded and that I was the victim of that fraud. And once I discovered it, I completely put the brakes on it. And then I was retaliated against using the official process of clean elections to basically try to ruin me, is what Bob Branch and the Power Fives has tried to do. The only way for me to move forward is to ask the commission to please end the investigation with regards to me as an individual. And I don't know if that's the right wording. Tom, you'll have to help me. Kara, I would need I don't know what the wording is. So I apologize, but Tom, is that the right wording?
No, well, yeah. I mean, I'm sorry, Madam Chair. I'm
not asking for legal counsel. I'm
no,
asking
I follow, Madam Chair, Commissioners. I think that, I mean, so just to recapitulate, I think what we're hearing, I think what Mr. Sloan is saying is, look, you got this matter under review. We could close it.
Yes, that's exactly what I'm saying. I have no problems with continuing to work with the commission with regards to what happened in the past, but also, and I've told Tom and Kara this, Bob Branch is continuing this fraud on other candidates. He has already signed up other candidates. He has already signed contracts to put a concert in place, to put other events in place. He is moving forward full steam ahead with total disregard for this commission, because his intent is to drain the Clean Elections Fund of money. As I've told you, he is promising services that he is not going to provide and can't provide. And I don't want to see other people end up in the situation that I'm in the stress that my family is under because of this civil suit, because the arbitrator didn't understand clean elections law, which is exactly what he was hoping for. And so I am throwing myself on the mercy of this commission and asking you to please end this.
Thank you, Mr. Sloan. It really is, I just hate hearing about the troubles that people have to go through with regard to disagreements like this that blow up and become litigation. So I am sorry about that for you and your family.
Thank you.
Let me ask, do any of the commissioners have comments or questions? And Tom, perhaps you could, would it be appropriate or acceptable to ask you to weigh in on your opinion on this?
I mean, if you're asking me that question, I think it is, but really, Ms. Cody would have to answer that question if you're asking.
Okay, well, maybe Ms. Cody can do it. I don't know if we've ever been in this situation before, and it seems very unique. And I can kind of understand, based on what Mr. Sloan is presenting, the broader lay of the land that, in law school, we studied cases and usually it seemed like it was family law that this type of stuff would happen in. But so perhaps, yes, Ms. Cody, could you weigh in on this? And
yes, Madam Chairwoman, Commissioners. There really are no rules guiding what you can ask of whomever is on the call. So certainly you could ask Mr. Collins to weigh in, but I would advise you that in your rules, when a matter is closed, it's typically because the commission has found after investigation or after a hearing that a violation did not occur. Here, it's at the discretion of the commission after some discussion whether you want to continue with the investigation or close the matter, but any motion I would ask if you do move to close it, would have more of a factual basis so you don't set the precedent of closing matters without coming to the conclusion that violation didn't occur. Here, there are extenuating circumstances, and so after you ask your questions of Mr. Collins and perhaps more of Mr. Sloan, then you can come to your own conclusions and make a motion to either continue the investigation or to close it for whatever reason.
Thank you. And actually that does, I guess I do have a question, and perhaps the other commissioners will have the same one or others, but for example, I really thought we had kind of put Mr. Sloan's case to bed. He had paid all the money back. And so I hate to confess, I was surprised we were still having his case hang around, because that makes me sound like I don't know what's going on. But I will admit, I apparently did not know what was going on.
And Madam Chair, if I can, please.
Sure, Mr. Sloan, go ahead.
I don't think that the issue is with regards to it just hanging around. I think the issue is regards to extenuating circumstances that are happening in civil court currently, right?
Yes.
The other part of that is, and to Ms. Cody's point, I think the factual basis is that there was an investigation. I have admitted that I entered into a contract improperly. I repaid $94,000 to the commission, which has got to be one of the highest repayments the commission has ever received. I was a steward of the money, and I have, in every step of this situation, tried to do the right thing. And so if there is a factual basis for saying that the investigation is over, that there has been a remedy, that those are the facts.
Thank you, Mr. Sloan. And I don't know if you're, going to run again, but if you do, I hope you'll consider running clean, because we really believe in this process. I just hate that you had such a horrible experience, apparently. Maybe.
Well, staff has been wonderful. Let me just be very clear. Staff has been terrific. They have always told me that they are not my legal counsel, which I greatly appreciate, because I don't know. They're always, it's been really, it's working with the clean election staff has not been an issue.
Wonderful to hear. I
There's
wouldn't expect
outside issues. Yeah.
Tom, do you have a position you could talk to us about on this?
Madam Chair, Commissioners, I take Ms. Cody's advice to heart. I think that's a fair point, and I agree with, and so I'm not sure within that, how you would craft that. But here's what we know. Everything. Without getting into the stuff we don't know, which is really the civil action side. It is true, and it's in all the memos associated with this, that it was Mr. Sloan's campaign that initially contacted us about this dispute, and they did follow the act with respect to how this dispute was to be treated. It's also true, and I'm sure you're not wrong. We had a substantive hearing in April. We had about the repayment order. We went through that. Mr. Sloan made it wasn't sworn, but what amounts to an allocution around those issues. So I don't know how you phrase how you put that phrasing together. I'll be candid. What I think is this. The reason we have this case open as a separate matter still is because of the fact that we are in a situation where we wanted to make sure that we retained jurisdiction over the transactions. We believe we have this jurisdiction over the transactions in two ways. We are not currently seeking additional penalties against Mr. Sloan. Like, if you were to say today, what do you want to do about this? We would not be in a position to say that we would be seeking a penalty on top of the repayment. We obviously are going to have to retain, and I think we have the authorization to, if we have to subpoena Mr. Sloan or his spouse, as part of the thing, we're going to have to do that. So we
would
not
fully comply.
Yeah. So we may not be we may not be done with the factual issues here. So the harder part here is, and I suppose maybe I should have been more effective as staff here. The harder part here, I think, really is the issue that Ms. Cody identified. So, for example, if we could put together a motion that simply said, like, look, we are going to conclude this matter, and based on the state representations of Mr. Sloan, we don't see the need to impose further penalties, and therefore we are closing it something along those lines that makes that record. I think I feel comfortable with that. And then Ms. Carlson has something to add, and Madam Chair, if you would recognize her, thanks.
Certainly, Ms. Carlson.
Madam Chair, Commissioners, the only thing that I would add, I think that Tom is on the right track. And again, I'm in this spot right now where I'm not advising you necessarily. I'm not advising you, but what I would advocate for is to include as part of that factual basis that there was a repayment that made a repayment of the remaining commission funds, because I do think that is important as part of the factual basis for concluding the investigation, that there was an investigation, there was, as you put it, Madam Chair, I think essentially an allocution, and there was a repayment of those funds, and on that basis, with all of those factors, I think that provides a good precedent for future investigations when we're moving forward. It's not just oh, well, you dismissed, this other case for no reason. We can say, no, there were very good reasons.
Yeah, I mean, I personally, on one hand, I hate to treat somebody differently from how we would treat a regular case, but I think this is just the first time somebody's actually come to us to ask us to close the case. And it's after all of this, he's cooperated with our investigation, repaid all the commission funds, been present at every meeting we've talked about this at, to add his information. And I think if anybody came to us in this way, we would be willing to consider it. I hope I'm not, I may or may not be speaking for all of us, but it doesn't mean we would always approve it. I don't know whether we will today. I'm interested to hear from the other commissioners, whether they have questions or comments, but those are kind of some of the concerns I have, I suppose, that we've just never done this before. But again, nobody's suggested it before. So there's a first time for everything, I suppose. Commissioner Meyer, did you have a comment or question?
I did. Thank you, Madam Chair. And I think I know the answer to this question, but I just want to make sure it's on the record. And this is a question for Tom and staff. It sounds like from the point that Mr. Sloan brought this issue to your attention or came to you regarding this, that he's been entirely cooperative and done everything you've asked him to do. Is there anything that the commission and staff have asked of Mr. Sloan that he has not done or not cooperated with since he came to the commission with this issue?
Madam Chair, Commissioner Meyer, no, I couldn't identify a thing.
Okay.
Tom, did you need to add?
No, like I said, the facts, putting aside the facts around we don't know, the interactions with the commission were, the campaign got in touch with us in, I don't know, August or something of 2020, and proceeded accordingly, and the complaint came after that. We don't know, we as Clean Election staff don't know all the things that happened in the intervening, that caused Mr. Branch to then bring this complaint. We don't. But we do know that like I said, Mr. Sloan has provided us those documents that we requested, and he has, yeah. So I'm trying to think through all the transactions we've had, and it's hard to find one. I can't find one that where we asked for something, didn't get it immediately. I mean, we got the repayment order done in very quickly. That was, I mean,
2 hours.
Yeah, that was I mean, that was in
That is
itself.
fast.
Yeah.
I mean,
so,
literally, we had the check written the second we signed the repayment order. I had the check written and drove it down to Clean Elections immediately.
So, I mean, that's yeah. So I'm just, Madam Chair, Commissioner Meyer, just to try to fill out the record a little bit there. You know, it's they brought the issue to us. When the complaint arose, they didn't withdraw from interacting with us. I would also note Mr. Sloan, because of the financial aspects of this is acting pro per, and I think that and as Mr. Sloan said, and I appreciate him saying, we have been in a position where we cannot ask, or we cannot we have to respect our roles as state employees and attorneys. So it's been, in other words, he's been navigating this in a way, in an environment where neither Kara nor I, as a professional nor legal matter, are in a position to assist him or to even really do anything other than tell him he shouldn't be talking to us. So, I mean, quite frankly, and so I don't know really what else to add, but other than under the conditions, you know, we've done repayments before. We've had candidates get involved in stuff, and some of them go south.
So, Madam Chair,
Yes.
I mean, we're stewards of this money, this Clean Elections funding money.
Mm-hmm.
Is it your findings, Tom, or your opinions that all the money, the Clean Election funding, was either appropriately spent by Mr. Sloan's campaign or returned to the commission?
Madam Chair, Commissioner Meyer, yes, under the terms of the repayment order, which is a comprehensive detailing of the accounting leading up to that is included in the order. And the order, yes, that is in fact correct. In fact, the $94,000 amounts to virtually the entirety of the primary funding that Mr. Sloan received.
Okay.
So, Ms. Cody, do you believe that we've kind of laid out enough of the facts here for our consideration that we could make a motion?
Madam Chairwoman, Commissioners, I do. I think that the rationale that has been discussed would be the cooperation of Mr. Sloan and the completion of the repayment order, or fulfillment of the repayment order, or some such wording.
Okay. Is there a commissioner who would like to make a motion on this? Do you need help with language?
I guess I just want to understand what closure of the file mean. Closure of this case means that the commission no longer has jurisdiction to investigate this anymore. But I guess, you know, with my litigator hat on, I mean, we have the case against the party of fives is ongoing. Is that's the case where you would use the fact that case is open as your vehicle to get any discovery that you need on that issue, right? I mean, we're done with Mr. Sloan, right?
Madam Chair, Commissioner Meyer, that's yes. We had maintained this case for, you know, really with the idea that if there was that the having the penalties available in the event that there was non-cooperation or things turned out to not be truthful, etc. Those were the kinds of things we're always concerned about. So, I mean, you know, we have, and I would say, and I want to make clear, because I think the chairwoman made a very good choice. Not yet, Representative. You know, that this isn't this isn't a, oh, this is what this is, you know, not our, this is not something anyone would have, it would happen to just anyone. I mean, we really do have a substantial a record here, and I mean, we have, frankly, we have many of the facts are not in dispute. Some of the facts are, and we need to get to the bottom of that. That's a whole other thing. But I just feel like we are not in a position where we would be seeking that additional penalty at this point. And so.
Okay, thank you. Yeah, I will say, Mr. Sloan, you've definitely stood out as an active participant, very cooperative participant in this whole process, which from my perspective as a commissioner, I really appreciate, especially since I used to do campaign finance enforcement at the Secretary of State's office. It's nice when you can kind of work cooperatively with the people you're doing enforcement against, since it can be an adversarial process. So thank you for that.
Thank you.
So having taken all of this into consideration, is it possible that one of you might have a motion, my fellow commissioners? Do we need help with language on that?
I think I have one here, Madam Chair, if I can make that.
Sure, Commissioner Meyer.
I would move that based upon the unique facts of Mr. Sloan's case, including the fact that Mr. Sloan has made repayment to the commission consistent with the order he agreed to, has been fully cooperative with the commission in investigating this matter since it was brought to the commission. And based upon the fact that the commission has done an investigation and is seeking no further penalties for Mr. Sloan, that we close this case.
Thank you. Do I have a second?
Commissioner Kimball, I second.
Thank you. All right, with that, we will take a vote. Commissioner Meyer, how do you vote?
Aye.
Commissioner Kimball?
Aye.
I vote aye as well. And with that, we will close MUR 20-04 regarding Eric Sloan. Congratulations.
Thank you very
Mr.
much.
Sloan.
I appreciate it.
And thank you for that cooperation. I'm sure that's, we really
Absolutely.
do
And
appreciate it.
again, without repeating myself, I'm happy to continue to cooperate with any of the investigations that have to do with the Power Fives and the Sloan campaign from 2020. But I did want to make the commission aware that the Power Fives is continuing to do business as it did in 2020. And so thank you so much. I really appreciate it. Thank you.
Thank you. All right, with that, we can move on to item 8, discussion and possible action on election of chairperson for 2022.
Madam Chair, can I make a brief comment on item number 7 before we move on?
Oh, certainly. I'm sorry, Commissioner Meyer, please.
I certainly understand. I'm very sympathetic and empathetic for what Mr. Sloan has gone through. And I just feel like he was an unknowing victim here of this scheme that we were talking about with the Party of Fives. And if there is, I don't know our training materials inside and out for the clean election candidate training, but maybe this is something we want to make sure that we're informing candidates above to very closely look at these consulting agreements and understand the risks. And I don't know if there's a way to run these agreements through commission staff before they're signed, as opposed to after the fact. And if this is already being done, forgive me, but I just want to put that on the record that if there's a way we can help future candidates avoid the scenario that Mr. Sloan has had to go through, let's do that.
Thank you. Oh, Tom?
Can I just want to, Madam Chair, I just want to say that we can take that as direction and make sure we review our materials. I mean, I can say with confidence that our materials cover this kind of, when obligations arise under the Act, they do. But I do think that, we can always shore that up and, and if necessary, and this is what I'm trying to, we can always look at, if we wanted to get that kind of information, we can talk about how to do that. Certainly, one thing we can tell people, and we have, well, I'll leave it there. We will take that in stride.
Okay. Thank you, Commissioner Meyer. That's an excellent suggestion.
Thank you.
And Thank you, Tom. All right, and with that, we can move on to the get a volunteer, perhaps. Well, we can talk about item 8. Every year we do elect a chairperson to chair meetings in the next calendar year. And we are at a crossroads that we have never been at before because we do not have a junior member to nominate or saddle with the job. We don't even have, all 5 of us here. And so I will say that I am happy to continue doing this job if you should want me to continue doing it. I know that just being a commissioner is a big job. It's disruptive once a month. It's an important job, in my opinion. But if one of the other commissioners is desiring of or willing to be the chairperson next year, I am more than happy to nominate that person, and we can vote on it today. So with that, yes,
Madam Chair,
Commissioner Kimball.
as you point out, we are in about 2.5 weeks going to be in unprecedented territory where all 5 of us are serving past the end of our term, and the people charged with appointing members have not followed through with their legal responsibility to do that for 5 years now, which is unfortunate. But we have I think, I don't know if it's a policy, but it's certainly a strong tradition of selecting a new chair every year. And I think it is incumbent upon us to carry forward in as normal a manner as possible, given the challenges that we're unexpectedly facing. And with no disrespect to you, Madam Chair, because I think you've done an excellent job this year, I would like to nominate Commissioner Meyer to be chair for 2022.
All right.
And I hope he'll accept.
Commissioner Meyer, your thoughts?
I don't know whether I should consider this appointment to be a lifetime appointment or a lifetime sentence at this point. And I say that jokingly. Tom, did you have something to say?
No, I don't have a better.
I think this whole situation is a little humorous, isn't it? We're doing a voluntold chairmanship now going forward.
Well, I joke because I don't know what else to do. I know I'm very honored to accept or to be nominated, and I just want to flesh this out a little bit more. I mean, 2022 is going to be a very big year for the commission, for the state with the midterms. And I am happy and more than willing to serve as chairperson of this commission. I am also a full-time practicing attorney and full-time dad. And I know, Commissioner, we're all working, we're all busy. I know, I'm not sure if either of you feel like you have more time to devote to the chairperson position. I'd like to hear from you on that. Again, I'm happy to do it, and I'm not rejecting the nomination, but I'm certainly maybe want to talk with you all a little bit about it more. And as far as the tradition of changing the chairmanship every year, tradition's been thrown out the window here, as all 5 of us are now past the 5-year plans. I personally would have no issue with Madam Chair, Commissioner Chan serving as chairperson again. I think you've done a great job. So I'll just throw those considerations out. I want to throw that out to you to kind of hear from you on that.
Well, and maybe Commissioner Kimball, I don't know. I know that you served perhaps more recently as chairman than Commissioner Meyer, but it was still a chairman, 2 chairmen removed. If you were going, would you be willing to consider being the new chairman next year, perhaps? I was trying to think in my mind, frankly, of who's not working full time. And I think it is Commissioner Kimball and myself. of the five of us, if I'm not mistaken. Because I know that that can be a factor now that we don't really have anybody new. What do you think, Commissioner Kimball? Would you?
Oh,
perhaps?
well, I wasn't, this is probably selfish, but I wasn't really thinking so much of who has the time to do it. I was thinking, as Commissioner Meyer pointed out, that 2022 is going to be a busy and challenging year. And for that reason, I think Commissioner Meyer is best suited to lead the commission during this. I think, Madam Chair, you've done an exceptional job this year, which has been a weird year. But I just don't think that we ought to say, well, tradition has been all upended, so let's just stop picking new chairs. I feel Chairman Meyer would be the best chair for this coming year, which is not really answering your question, but that's my feelings.
Okay. Well, no, I mean, that's perfectly acceptable. Well, Commissioner Meyer, I think Commissioner Kimball has made his feelings known. And, I don't know if we should take a vote today or wait and see if any of the others want to offer themselves up as chair people.
Commissioner Chan, what's your opinion?
I mean, I would like it to be someone who's willing to accept it. And if you are, I'm happy to support your nomination. I understand, I feel like there's, again, because of the fact that everybody's here now, going to be here past their expiration date next year. I was thinking about rolling back through seniority, even. But I also feel like once people's seats have expired, they move on in a little bit of a regard, not that they don't participate, but to go back through seniority. So, but I have no problem switching chairs. I just
Madam
get to
Chair,
see.
I think seniority is a good point, and I would have nominated Commissioner Titla, but he has challenges of his own at getting to meetings, and so the next most senior member is Commissioner Meyer.
Okay. Well, based upon the comments from my fellow commissioners, I will accept the nomination.
All right. Excellent.
Do we vote? I don't.
Yeah, I think we do vote.
You have voted historically.
And I made a motion, which I don't know if it's been seconded.
Oh, then I will second the motion. And then we'll call the roll. Commissioner Meyer, how do you vote?
Aye.
Commissioner Kimball, how do you vote?
Aye.
And I vote aye as well. And by a vote of 3-0, Commissioner Meyer, you are chairman for the second time, which I don't know if that's been done in the history of the commission, but congratulations.
It happened one time.
Oh, it did?
Oh, don't burst my bubble.
I'm sorry. I mean, I'm sorry. I take it back. It never happened.
In our recent memory, for all of us.
Yes. You would have had
a historical event. So congratulations.
Mike, Paula, and I are the only three people who actually know that. So if the rest of you forget it, it never happened.
Okay.
This is being live streamed by millions.
It should be. All right. Item 9, we can move on to public comments. So this is the time for consideration of comments and suggestions from the public. Action taken as a result of public comment will be limited to directing staff to study the matter or rescheduling the matter for further consideration and decision at a later date or responding to criticism. So does any member of the public wish to make comments at this time? You can, I see Rivko's here with her hand raised. I'll just note that you can also send comments to the commission by mail or email at ccec@azcleanelections.gov. So, Ms. Knox.
My name is Rufko Knox, for the record. I'm just speaking as a citizen of the state of Arizona and a voter. Madam Chair and members of the commission, all three of you. I wanted, first of all, to one more time tell you how very much I enjoy and learn from participating in these meetings about the law and the intricacies of the law. I'm not an attorney and never have been. I also wanted to thank all three of you for continuing to serve. I know last time I made a comment, a month ago, I made a comment about my ongoing, and it's true, my ongoing concern about the lack of nomination of new commissioners. And I don't know at this point what anybody, I know I'm not sure there's anything I can do, but the main point I wanted to make is what a tremendous program the commission sponsored yesterday with the Arizona Capitol Times Morning Scoop, at which Gina Roberts, who I found out her real name is Regina Roberts, but that's how it goes. After 8 years or something, I finally found that out. Did an amazing job. The entire program was beautiful, very well organized, very knowledgeable people spoke. All the speakers were experts in what they talked about and spoke to facts. Unfortunately, there was one person in the chat who was off on a different dimension, I suppose one might say. But the nice thing was that most of the comments were either asking questions or complimenting the speakers. And I'm just so happy at the wonderful institution that this is and that it continues. And I'm not sure if this is appropriate for me to say or not, but as you know, I am no longer the league assigned observer or representative here. And I know a new person has been assigned, and all I can say is I hope that that person is staying in touch with you, Mr. Collins, as executive director, and the commissioners, and adequately reporting. I do send a report of the meetings that I attend or observe afterwards if I'm unable to actually be there on the day, to a few people in the league who are interested. But I just hope the connection stays, especially with the importance of this upcoming election year 2022. Thank you very much. And I look forward to seeing all or listening to all of you next month. Happy holidays.
Thank you, Rivko. Same to you. Happy holidays, Happy New Year. And is there anyone else who wishes to speak? I don't even know if there's any other members of the public here. I don't think so. So in that case, we will move on to item, I don't know which items this, oh, it's item 10, excuse me. Adjournment, motion to adjourn. So I would entertain a motion to adjourn.
Madam Chair,
Commissioner Kimball.
I move that we adjourn.
Okay, is there a second?
Second.
All right, let's call the roll. Commissioner Meyer.
Aye.
Commissioner Kimball.
Aye.
And I vote aye as well. And with that, we are adjourned. Everybody, go be safe. Have a wonderful holiday and Happy New Year. And we'll see you back.